Hello everybody, my name is Jake Kim. I am here to tell you about a game named VR Chat. It's a social game where you guys can actually chat and interact with friends. But today I'm not here to tell you about this. I'm here to tell you about the world of drama court. Now, it's like a virtual court, but keep in mind that we use actual factual objections, motions, and amendments. Certain amendments that can be used in court, in virtual court. Now, keep in mind that I'm not an attorney. I just have to know these kind of things just through various web sources. So if you guys are looking for an actual legal advice and whatnot, consult your actual attorney to your nearest state. Now let's get right to the objections. First of all, objections are something that can be argued upon by attorneys. So let's say, for example, an attorney wants to object something that seems very unnecessary or just seems rather wrong, then these are the objections that you guys can say. Now, authentication. Now, authentication is basically it's self-explanatory, objecting when there's doubt about the genuineness or source of a piece of evidence. So let's say the attorney doesn't state or specify who made or analyzed the evidence for the court. This should be very necessary for any attorney, real attorney, I mean, because if you state who is from or where the source is from, then the person should obviously this is basically confrontational if anything that involves uh contacting or anything that goes in contact with the defendant. So that's authentication or it goes for confrontation. So the if you have any authentication, you obviously need to bring a witness for that. Hearsay. Objecting to statements made outside the court offers evidence to prove the truth of the matter asserted. So the actual statement is an out of court statement offered, like I said, as evidence to prove the truth of the matter asserted. So anything that is stated from a person that directly offers the truth towards the accuser or the accused, basically as evidence, like testimonies, affidavits, or any form of statement that is from outside of the court, cannot be used unless they hear the state as it is today, or in that trial. Relevance. Objecting when evidence is testimony is not directly related. This should be self-explanatory. If it's not related, like say for example a murder charge, but they're showing like evidence of person being beaten up for assault, that is highly irrelevant. That is something that cannot be used. Speculation. This is like opinion, but in a way to just guess or speculate. Let's say if saying I think or we believe, that is speculative. That's something that you should not say. A good attorney has to be affirmative or confirmed about their facts and such. So that is something that you should be aware of for when it comes to speculation. Now, when it comes towards witnesses, there are multiple things that I said in the evidences that can be used towards witnesses, but this can also be used in witnesses mainly. Compound question. Objecting when a question asks more than one thing at a time, make it difficult for the witness to answer clearly. Let's say, for example, the setting is the wedding. What color was the car? How tall was the cake? How many people were at your party? That is something that is not related to this simple subject alone. Let's say, for example, the wedding dress. Was there blood on the wedding dress? Or that can be considered as leading, which we'll go on later on. But let's say, for example, was there, what color was the wedding dress? How tall was the cake? And simple things like foundation site, things that you want to be like. Let's do this one easier. Let's do like addresses. What is your address? What is the city? What is the state that has been stated? That kind of thing can actually matter because that's all within one subject. Let's say, for example, in a mail, an envelope from a mail, right? That can be considered as using that for not as compound. So keep that in mind when you're saying compound questions that's not off the scope of the setting of the questioning. Leading the witness, objecting when an attorney's question suggests the answer to the witness. Is it true that? Can you say that? Were you there when? Or more. There are all forms of leading to give the clues to witness to lead the story. Remember, the witness has to say the story for themselves, not you, not the attorney. So keep that in mind. Narrative is self-explanatory. Is you just basically yamble that is not outside of the scope. If they are stating something that is basically informative or something that's full of important information, just let it go. I usually let it go because sometimes there might be information that could be counted as important to contradict, so that way you can just hold it until the very end for your closing arguments. So keep that in mind. But don't say anything that is unless narrative, which is outside their scope of important information. Now, next one. Non-responsive, it should be self-explanatory. It's obviously when the witness doesn't answer or refuses to answer. Basically, unless it relates to is privileged information, sensitive information to regards to attorney-client or doctor-patient, which we go on later on. That is something that can be as non-responsive. You could just say, Your Honor, this is not responsive to my simple question. Vague or ambiguous. This is something that is self-explanatory. Also, which is a question is statement is unclear and could have multiple interpretations. Where were you and what were you doing? Well, where were you is basically on the foundation. What were you doing? There we go. That is something vague or ambiguous because that is something that unless the foundation has been set, then that's something that's a question you should not be saying. It's basically saying what were you doing as a foundation when we haven't started yet. That's good. But when like say saying oh, I was milking the cow, and what were you doing then? That's something. Oh, that's also that's actually really good. These kind of things is I can't really explain, but you will understand when you are kind of confused about what the question is interpreted as. So keep that in mind about vague or ambiguous. Even I can't really explain to how it works. Special objections, things that had been things that special objections that have not been common, but they can be used in court too. Assuming facts not found evidence. Now, as a good attorney, you have to obviously provide all facts, all evidence. But assuming the facts are not found in evidence in drama court, you can actually object for that when a question or statement assumes something that has not been proven yet. If we have gone up to witnesses and we already passed evidence phase, that is something that could be used as an objection. Best of evidence rule, that's something that we obviously don't use because everything evidence that we provide is considered as original. So keep that in mind. Now, character evidence is objecting when a character evidence is introduced to show a person's general character, which may not be relevant to the case. Um, Unless if the defense brings in their evidence of good character, then that character of bad character cannot be used. So let's say, for example, prosecution brings evidence like as of bad nature to the defendant, unless the defense brings in evidence of their good character, that evidence of bad character cannot be used because obviously that's something that you should not be using for an ethical purpose. Cumulative evidence is objecting when evidence being presented is repetitive and unnecessary. Let's say, for example, bring in a hammer. Let's say, for example, Your Honor, we have a hammer being used here, and we also have evidence to show you the facts of a hammer. One, unnecessary, and two, that's very repetitive in a sense because we already know we already know what a hammer is. There's no reason for us to bring facts about a hammer. So that's something to keep in mind. Mischaracterization, objecting when opposing counsel misstates evidence or testimony. If they misstate something that they know for sure they're trying to do on purpose, then you could call for mischaracterization. So that's something you gotta be aware about. Unauthenticated photographs or unauthenticated evidence is necessary. Objecting when photographs are presented without proper authentication or context. Um, if they're being obtained without a search warrant or so, like any kind of video, photographs, basically anything that violates the Fourth Amendment in that sense cannot be used. I believe in that sense, but anything that's based beyond like search or seizure, like photographs or video evidence without proper authentication, cannot be used. Unfair prejudice, objecting when evidence might unfairly sway the jury's emotion rather than rely on the facts of the case. This counts like an argument. Like for example, striking over the shoulder, which would be improper jury argument, which would be like a special one. Objecting when evidence might unfairly sway the jury's emotions. So instead of looking at the facts, they're gonna say like, um, I don't understand how emotions work for the jury, but it's something that's very unethical that you might say like, you know, this person might beat a dog. Think about how bad that could be to your eyes. That could be considered as unethical rather than swaying the jury's emotions. They'd be like, "Oh, that's so bad," you know. But instead of relying on the facts of the case, you know, say he did kick a dog, that'd be unfair. That'd be really bad. But that considers relying on the facts of the case, I believe. But I could be wrong. Now, legal towards witnesses, improper expert testimony. If the person is not an expert witness, therefore you can actually consider object to that as improper expert testimony. Unless they set the foundation, then you can actually motion the judge to label them as an expert witness. Legal conclusion, objecting when a witness is asked to provide a legal opinion or conclusion, as this is the role of the judge. Let's say, for example, the person walks up to them and just give them the cross-examination. I will tell them, uh, after looking at the facts and all that, do you think they are guilty as they are? Yes or no? Your Honor, objection. Jumps to a legal conclusion. That is up to the role of the judge. You cannot say if they're guilty or not. That is up to them. After that, you should be done. Next one, opinion. Objecting when a witness gives an opinion or conclusion that requires specialized knowledge that they may not possess. That is something like, for example, a person says something like a pilot would say, something like a police officer would say, like you, oh yeah, I know about my runner rights and know how to. That's something that obviously that you should know as your public citizen. But let's say for example, uh, something about attorney-client privileges, yada yada yada, and I was like, oh, I didn't know you were an attorney. You're not objection within like opinion like towards the witness because they have knowledge of they may have they say there's something about special knowledge that attorney would know that they don't know. They're not attorney, something like that. That's opinion, I guess. That's something that could be used. Privilege, objecting when a question seeks information protected by attorney-client privileges, doctor-patient privilege, etc. That's something I already said before. Something about sensitive information that should not be used because that's basically a personal information that is from the client or the patient. So I believe that's all of the objections. If you guys like that, you guys can click the subscribe button. Remember, I am not an actual attorney. If you guys need to seek the legal advice, you can consult the actual attorney. But these are rejections, and we will have more considering motions or amendments that you guys can use in drama court. Keep that in mind that these objections can really help you in the long run in terms of virtual court when playing this game. Thank you so much, and as always, I will see you guys next time. Bye bye.